Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. If you're not sure what your workplace rights are, this is the show for you. Welcome to Ask a Lawyer. I'm your host, Dana Levinson. Every week, we examine myths and clear up the confusion about your employment rights in Canada and how to get the advice and compensation you need. Employment lawyer Lior Sampiru is here once again, co-founding partner at EmploymentLawyer.ca. Before we get to today's questions and phone calls, Lior, tell us why it's important that everyone knows their employment rights, and perhaps you can talk about a significant case happened this week.
Absolutely. Now, Dana, you and I tend to talk before the show, and we talk about employment law, and you always have questions to me, and I always say things that you didn't necessarily know, and I think that is a good indication of the public at large. There's a lot of questions. There's a lot of misconceptions about employment law, and things that you believe to be true, in fact, may not be true, and that's why I think it's so important that we do this show and that people inform themselves and educate themselves about their workplace rights. It's an important thing, our job. We spend more time working than we do anything else. Mm-hmm. And it's imperative that we know our rights, we know our options, and we know how to deal with situations where something went wrong. It's not always going to be perfect. And now, if you watch the show, you'll know what to do when something happens. We have EmploymentLawyer.ca for you to learn a lot more about your workplace rights. And certainly, I'm always happy to talk to people that have questions, have issues, so I can get working on helping them. Let me give you an example of a situation that came across my desk over the past few days. I spoke with an individual who was off on holidays for a number of weeks. Just as he was returning, getting ready to come back to work, company said, we're going to need to make some changes. Instead of you being a regular employee, he'd been employed there for some 6 years or so, we're going to have you now be a contractor, no guaranteed hours. We're going to try to give you as much work as we can, but we can't guarantee you 20, 30, 40 hours a week. You're not going to be part of our benefits plan. And we'll evaluate again after a year. You're shaking your head, and you're right to do so, because no, the company can't do that. He called me, of course, very upset, concerned. I've been working there for 6 years. Can they just pull the rug from under me that way? Absolutely not. All those things that I've just described, no guaranteed hours, no benefits, those are very significant changes to terms of employment. And anytime your employer makes such changes, this idea of constructive dismissal should immediately come to mind. If your employer takes the job that you have, and now all of a sudden it's a very different job in terms of hours, compensation, location, responsibilities, constructive dismissal. That means you don't have to accept it. You don't have to continue working based on those new terms. You can treat your employment as being terminated and get severance. His employer did not have a right to make him a contractor after him being an employee for 6 years. That's a termination, and if they want to rehire him after they paid him severance, they can have that discussion. It's not something the company can do unilateral. Now, your situation may be different. It's not maybe a contractor. Maybe they just want to change your shift. Again, constructive dismissal. Anytime you're looking at a significant change, take a step back. It's not something your employer is allowed to do.
Okay, and always a good advice to get in touch with an employment lawyer. So you can contact Lior directly by going to EmploymentLawyer.ca or calling 1-888-861-4555. Let's get to our first call of the show, Lior. These calls come from your show, which is across Ontario, across Canada, and you take questions live from people about their employment rights. So I'd like to hear our first call. Take a listen.
I was let go from a firm after 13 months, transferred over from another firm I was poached over, and they've offered me 1 month severance, and I keep my benefits up for a month.
How long did you work for the other company for?
7 years. We work in a similar trade, saw each other on job sites, different meetings.
How old are you?
47.
Tell me about the compensation level in terms of salary.
I'm $150K.
Well, it's certainly a very frustrating thing. You have a secure job, you're being recruited away, you're starting to work in good faith, all of a sudden they let you go, nothing wrong that you did, and you're obviously very frustrated having walked away from a job. Well, the law knows how to address that, and the law deals with that. In a situation where you're actually recruited away, you had a secure job, the company recruited you, and then they let you go. The severance that you're going to be owed is going to be based on the time that you had with the previous company. So even though you may have worked like this person for a year only with this new company, but he had 7 years with the previous company, he was recruited away. Now when he gets paid severance, he's an 8-year employee for severance purposes. Now, let me say this. Even as a 1-year employee, he would have been owed much more than 1 month severance, potentially 4 or 5 months of severance, even after 1 year. But he's not a 1-year employee, he's an 8-year employee. So let's see how much severance he gets because he was recruited. And rather than me just tell you, let's take this information and let's plug it into our severance calculator, which you, of course, you can find at EmploymentLawyer.ca. And let's see how much severance this person is actually owed. So we know that he's in a professional role, been there for 8 years, as I said, 1 year plus the 7 years that he was recruited from. 47 years of age, was offered 1 month's pay. You see on the screen he's owed as much as 14 months' pay. Somewhere north of a year is what he is owed. So an extra year's pay over and above what he's owed. That's why it's so important to get advice if you lose your job. You may have sources of rights and entitlements that you don't even realize, certainly if you've been recruited away, and it does start with going to PocketEmploymentLawyer.ca.
And such a huge topic, too, being recruited by other companies. People do not realize that they have that right if they're let go by the new employer.
Most
Such
people
good information.
don't appreciate that. And the other thing I'll say on this idea of being recruited away, if you are going to be recruited away, be careful with what you sign. Don't agree to be on probation if you've left a secure job. Don't agree to limit your future severance. So be very smart if you accept a job when you're not looking. When they've recruited you, you have more negotiating power then.
Okay. Great information. Let's take a quick break. And when we come back, employment lawyer Lior Samfiru from EmploymentLawyer.ca will discuss pervasive severance pay myths in Canada. Back with more after this short break. Stay with us. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. And welcome back to Ask a Lawyer. Employment lawyer Lior Samfiru from EmploymentLawyer.ca is taking your employment law questions. If you want to get in touch with Lior and his team, you can call 1-888-861-4555, email ask@employmentlawyer.ca, or go to EmploymentLawyer.ca. We have more calls and questions coming up, but before we jump to those, we want to talk about today's main topic, which is severance myths. So let's talk about that, okay? Myth number 1, when you are fired, you get only 1 or 2 weeks for every year of service.
That's the big one.
That's huge.
You know, we're starting with the big one right there. And
yeah.
You can ask 5 people, you know, on the street right now, what do you get if you lose your job? How many weeks per year? Some will say a week, some 2 weeks, some will say a month, some will say 2 days. And guess what? They're all wrong. These are all myths. None of those are correct.
All of them.
All of them. There is no rule of a week per year, 2 weeks per year. Nonsense. It's not a linear equation. Remember, your entitlements, if you lose your job, your severance entitlements are based on a number of factors. Your age, your position, the length of your employment, your employability, all those are factors that go into assessing your severance. So it's not as simple as, well, I lost my job, I get a week, or I lost my job, I get 2 weeks. And for most people, they're owed a lot more than a week or 2 weeks per year of service. It could be owed a month, 2 months, 3 months, 5 months per year of service. You could have an employee that's worked for a year and be owed 6 months of severance. So all of a sudden, that's 6 months per year of service. The older you are, of course, the more senior a position, the longer you work, ultimately the more severance. So I've seen time and time again, Dana, individuals accepting inadequate severance because they assume, well, I'm only owed a week per year. They've offered me slightly more than that, so I guess I should accept that. when in fact they could have been owed 5 times what they've been offered,
Wow.
10 times what they've been offered. So it's not that simple. That's why we created our severance calculator, which we've talked about. You can find it at EmploymentLawyer.ca, that allows you to find out the real amount, what you're really owed, not this silliness of a week per year of service, the actual amount. So check it out. It's free and anonymous. You have to inform yourself and be educated on that.
Okay, so that is a big one. That was number one. Number two, your employer says you've been fired for cause, so you aren't owed anything.
So this is a very common myth. Well, the company says I did something wrong. Maybe I actually did. So they're letting me go with no severance. I guess that means that's it for me, no severance. Wrong. That's a myth. That's a misconception. It's simply false. The only time a company can legally let an employee go without severance is not just if the employee did something wrong. That employee would have had to do something terrible, something so bad that it's just impossible to continue employing them. And time again, for years and years, I've seen so many situations where someone did something wrong, company lets them go, says no severance. No, that's a wrongful dismissal. You're owed severance unless you did something terrible. It's very difficult to establish cause. So even if you don't have clean hands, even if you did something, you are still owed severance. That doesn't mean the company can't let you go. Company can let you go pretty much for any reason, but they have to pay you your severance, which could be, and easily is often, as much as 24 months' pay.
Wow. Okay. Third on our list of severance myths. Being on contract means you don't get any severance.
This is a very common situation. Individuals being misclassified. So they're called a contractor, they're told they're on contract. And that means, well, we decided to end this contract, this relationship, we're not going to pay you severance. But in most of these cases, individuals, in fact, are employees in the eyes of the law, but have been misclassified. They've been told that they're contractors, when in fact, it doesn't matter what the company says that you are. It doesn't even matter what you think that you are. The law makes that determination. And if you look like an employee and act like an employee, you are an employee. So the fact that you believe, or the company says, or you signed a piece of paper saying you're on contract, does not mean you don't get severance. You absolutely get severance. Again, as much as 2 years' pay. So don't let anyone tell you that being on contract means no severance. Not true.
Okay. Myth number 4. Short service employees get very little severance.
Well, it's easy to think, well, I only work for a company for a few months. If they let me go, what am I going to get, a week's pay if I'm really lucky? Easy to think that. And in a way, I guess it would make sense. Except false. Wrong. It's a myth. Not only that, short service employees, employees with 3-year seniority or less, are treated disproportionately better than long service employees when it comes to severance. So you may have only worked for a few months and you're let go. You could be owed a few months severance. Sometimes the length of the severance can actually exceed the length of employment. You worked for 4 months and you're owed 6 months severance. Very common. So please don't ever believe that just because you're a short service employee or a part-time employee that you don't get severance. You'll get a substantial amount of severance, and if you don't get it, again, that's a wrongful dismissal that, by the way, it's not that difficult to resolve.
Wow, these myths, wow, there's something. Okay, number 5 on our myths about severance pay. Your rights to severance expire if you don't accept your employee's deadline.
What a myth. So,
I've heard that so many times, Lior.
and every single person that has been let go and they're staring at that severance letter, there'd be a deadline there. Usually it's Friday. You have to sign this by Friday at 5, or we're not going to pay you. And everyone that's ever seen it knows exactly what I'm talking about. And it's easy to think, well, I have to sign this by Friday. It says so, otherwise I'm not going to get it. Nonsense. Your legal rights don't expire Friday at 5 or Tuesday at 3 or whatever it is. Your legal rights don't expire for 2 years. And the company can't impose a unilateral deadline. Now, if the company's offering you much more severance than they should be offering you because they're generous, well, you may want to accept that before they change their mind. But I've been doing this for 20 years, Dana, and I haven't seen offers that are better than what they need to be. So don't worry about that deadline. I'm here on TV saying you can ignore it. It's meaningless. It doesn't do anything. And if you sign it because you feel that pressure, you can't get out of it, even though you realize the next day you're owed more. So bottom line is, if you lose your job, you're staring at that deadline, take the time that you need to get advice, even if it means going beyond that Friday. Your legal rights won't expire.
Great advice, Lior. You can contact Lior and his employment law team for help at EmploymentLawyer.ca. Let's jump to another phone call from one of your radio shows. Take a listen.
It's regarding my wife. She was off on 2-year long-term disability and came back to work with some restrictions and limitations. They had a doctor's letter to say that she can't work past a certain time in the afternoon, but her employer, they specifically scheduled her past that. So she's been leaving work, as her doctor says, and she's getting docked the hours that she's not there. Are they allowed to do that?
So here's how this works. Ultimately, for medical reasons or other reasons, an employee can't work their regular hours. An employer is not required to pay them their full salary if they can't do their job fully. The employer has to accommodate and give them the flexibility to work less hours, but that doesn't mean that the employer is going to pay full wages if the person is working half the hours. But the employer still has to find a way, if at all possible, to try to supplement those hours. Maybe, yes, you can work 9 to 5, but can you work evenings maybe to make up for it if you want? Can you work weekends? Is there something that we can do to allow you to make up for what you've lost? You can't simply say, well, too bad you're working less, we're going to pay you less. If there's a medical condition, an employer should explore all options. If there aren't any options, really the only time you can work is 9 to 5. If for medical reasons you can't do that, you cannot be let go, you cannot be fired or punished in any way, but your employer is allowed to only pay you for the hours that you actually work.
Okay, you can connect with Lior Sampiero and his team by emailing ask@EmploymentLawyer.ca or going to EmploymentLawyer.ca. After the break, we'll talk about what happens when a new owner and a new location and a supposed 5-year termination threshold. Stay with us. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. And welcome back to Ask a Lawyer. Employment lawyer Lior Sampiero from EmploymentLawyer.ca is taking questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888-861-4555. Email ask@EmploymentLawyer.ca or go to EmploymentLawyer.ca. We still have lots of questions and emails to get through. Let's listen to this one from your radio show.
I was working for an employer. We were bought out by a company, and they wanted to close down the location that I was working at and move everybody to a new location. It was a good distance away from the two, like in between the two locations, about a 20-minute drive to about an hour and 15 minutes. Does the employer have to compensate their employees for moving to the new location, or is that kind of considered a way of a dismissal as well?
So a lot of things to talk about here. First of all, remember, if you're working for a company and that company is bought over by another company and you continue working, that new company inherits your service. That's very important to remember that, because if down the road they let you go, your service hasn't started anew just because there's a purchase, and you'll have to get paid in your severance based on your total years. That's very important to remember. But beyond that, if a company is relocating and you're told that you have to relocate, if it impacts you in a significant way, that results in a constructive dismissal. Usually we're talking about if it's an extra hour. If this is a result of the relocation, now you have to commute an extra hour each way, more than what you had to before, that's when we're in constructive dismissal territory. So whereas there's no way to force the company to pay you extra money for this extra drive, you can ask, but you can't make them. What you can do if you can choose to reject the change and say, I'm not making the move. Instead, I'm treating my employment as being terminated, and now you have to pay me severance. So it's not every relocation that results in a constructive dismissal. We do need that 1 hour threshold, but it is a very common thing, and I know a lot of people that have chosen to pursue constructive dismissal instead of relocating and making that extra long drive.
Okay, time for another situation that your firm has encountered, Lior. Let's take a listen, and also let's read what's happened from this email. I was fired from my office manager job after 4 years because I complained to HR about harassment by a new VP who constantly told me I was useless and too old for the job. I'm 54 years old. I was then told that I wasn't entitled to any severance because I worked less than 5 years. Wow.
Wow is right.
Wow.
And where do I start
Right.
with this one? Well,
Yeah.
let's talk about this briefly. First of all, an employer has to take very seriously anytime there's harassment, complaints, allegations. It's something that an employer has to eradicate from the workplace. We all have the right to work in a harassment-free work environment, to work in a supportive and positive work environment. And if a company ignores that, they say, well, we're not going to do anything about it. You worry about that. It's your problem. That's illegal. They're breaking the law, and there's going to be legal consequences under various statutes, including human rights. So right off the bat, this employer is doing something wrong. Now, if they make it even worse by firing this person that had the audacity to complain that they're being mistreated, we call that a reprisal. It's illegal. You cannot be punished ever for complaining about harassment. That's not something a company can do. And of course, there's consequences for that. And finally, nonsense, this whole idea of 5-year threshold for severance. I hear that all the time. Well, I can only get severance after working for 5 years. Ridiculous. If you had a job and you lost that job, you're owed severance. We talked earlier about the fact that even after a few months, you could be owed a few months severance. So there's a wrongful dismissal to boot here as well. So if this employer could have done more things wrong, I don't know what they could have done more. They really made a mess out of the situation. There's going to be significant consequences.
Let's take a break. We'll be back with more Ask a Lawyer after this. Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24. And that's all the time that we have for today. Lior, as always, thank you so much for being here today. Great information. You can catch legal experts from EmploymentLawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on this show at EmploymentLawyer.ca, visit cp24.com/askalawyer. Join us again next week as we answer some of the most common employment law questions in Ontario. Thanks for watching.